You want to play lawyer, sweetheart? Regional Director Clifton Marsh leaned back in his leather chair, folding his hands across his chest with the slow, deliberate satisfaction of a man who had never once lost. Go ahead. File whatever you want. By the time this is over, your mother won't have a job, a pension, or a roof over her head, and neither will you. Ivory Baines stood in the doorway of his corner office on the 14th floor, holding a manila folder so tightly the edges bent. She was 23 years old, wearing a blazer she had borrowed from her cousin, and shoes that were half a size too small. The folder contained everything. She had spent 4 months building it. Marsh looked at her the way a man looks at a pothole he's about to drive over. She turned and walked out without another word. Behind her, she heard him laugh. They had no idea what she had just decided to do. The Baltimore District Office of the U.S. Department of Labor's Wage and Hour Division occupied the 3rd floor of a building that smelled like industrial carpet cleaner and decades of unresolved grievances. Ivory had worked there for 2 years as a compliance analyst, a job she had fought for with every scholarship, every late night, every double shift. Her mother had worked to keep the lights on, while Ivory finished her degree in labor economics at Morgan State. Her mother, Ivory Baines, had been a shift supervisor at the same federal building's contracted cleaning service for 11 years. 11 years of arriving before sunrise, training new hires, covering shifts when people called out, and watching her meager hourly wage stay frozen while the cost of everything around her climbed. Ruthann was 54 years old with knees that ached in cold weather and a loyalty to her employer that bordered on heartbreaking. She believed, in the deep-down way that certain people believe things, that if you showed up and did the work, the institution would take care of you. The institution did not take care of her. 6 months ago, Ruthann and 14 other cleaning staff had been reclassified. Marsh, who oversaw labor compliance for the entire Mid-Atlantic region, had pushed through a contractor redesignation that quietly shifted their status from full-time employees to flexible schedule independent contractors. On paper, nothing changed. Same building, same hours, same uniforms, same supervisors giving them the same orders. But the reclassification meant the cleaning staff no longer qualified for federal overtime protections under the Fair Labor Standards Act. It meant no more employer contributions to health insurance, no more accruing pension credits, and because the redesignation was backdated 3 months, it also meant clawbacks. The company demanded repayment of what it now called overpaid benefits. Ruthann received a letter informing her that $200 would be garnished from her wages over the next 6 months to repay benefits she had already received and used. She hadn't told Ivory at first. She'd folded the letter and put it at the back of a kitchen drawer, behind the takeout menus and rubber bands, the way people hide things they don't have the language to explain. Ivory found it on a Sunday afternoon while looking for scissors. She sat at the kitchen table and read it 3 times. Then she read it a 4th time. Then she went to her laptop and started reading the Fair Labor Standards Act. She did not sleep that night. What Ivory found over the following weeks was not complicated. It was actually almost insultingly simple. The economic reality test, the standard the Department of Labor itself used to determine whether a worker was an employee or an independent contractor, looked at factors like control over work schedules, provision of equipment, and the permanency of the working relationship. Ruthann and her co-workers failed every single factor for independent contractor status. They were employees. They had always been employees. The reclassification was not a grey area. It was not a matter of interpretation. It was legally indefensible. Marsh knew it. Ivory was certain he knew it. Because Marsh had spent 21 years in labor compliance. He had written training materials on the economic reality test. His name was on a federal guidance document about contractor misclassification from 2014. He hadn't made a mistake. He had made a calculation. The cleaning staff were mostly black women between the ages of 40 and 65. Most of them had limited formal education. None of them had union representation. Several of them were undocumented or had family members who were. They were the kind of workers who did not file complaints because they had learned, across entire lifetimes, that filing complaints was how you lost the job you couldn't afford to lose. Marsh had bet on their silence. Ivory was not silent. She began documenting everything. She pulled the original employment contracts, the benefit enrollment forms, the time logs, the shift assignment records. She filed a public records request for the internal communications surrounding the reclassification. She interviewed 12 of the 15 affected workers sitting at their kitchen tables and in their cars during lunch breaks, recording their accounts in a spiral notebook with a broken spiral. She cross-referenced everything against the Department of Labor's own enforcement guidelines. When she walked into Marsh's office to present her findings, she had believed, with the specific naivety of a 23-year-old who had studied the rules and trusted them, that he would look at the folder and recognize that he had been caught. Instead, he laughed. The next morning, Ivory received a letter from Human Resources informing her that she was being placed on administrative leave, pending an internal review of potential conflicts of interest arising from personal relationships with individuals, subject to departmental oversight. They had taken her badge before she finished reading it. She stood in the parking garage, badge gone, box of desk items in her arms, the folder still in her bag, and thought about what Marsh had said. File whatever you want. She thought about her mother's knees. She thought about the $4,200. She thought about the other 14 women who had shown up in the cold and said nothing because they believed saying something would cost them everything. She thought, fine. She filed. The administrative hearing was scheduled for 9 weeks later before a federal administrative law judge. It was a proceeding that, on its surface, resembled a courtroom but operated under its own set of procedural rules. Rules that Ivory, who was not a lawyer, spent those 9 weeks learning with the focused desperation of someone who understands that preparation is the only advantage they have. She could not afford an attorney. The civil rights organizations she contacted were overwhelmed. A law school clinic expressed interest but couldn't take the case in time, so she did what she had to do. She pulled every administrative hearing transcript she could access through public records. She studied the federal rules of evidence. She read the Administrative Procedure Act. She found 2 relevant Sixth Circuit decisions about contractor misclassification and read them until she could recite the reasoning from memory. She also kept her day job, technically. Administrative leave meant she was still on the payroll, still receiving direct deposits that she was not touching, saving every dollar in case the hearing went sideways, and she needed money for something she couldn't yet name. Marsh did not represent himself. The department retained outside counsel, a partner from a DC firm named Gerald Whitmore. Whitmore was 62, had argued before the Supreme Court twice, and had a voice that seemed to have been engineered specifically to make opposing counsel feel stupid. He wore a watch that cost more than Ruth Ann made in a year. On the morning of the hearing, Ruth Ann insisted on coming. Ivory told her not to. They argued about it in the parking lot of the federal building for 7 minutes, and then Ruth Ann said, quietly, "That's my name on those forms, baby. I'm going," and that was the end of it. Administrative Law Judge Patricia Shen called the room to order at 9 o'clock sharp. She was a small woman with reading glasses on a beaded chain, and an expression that suggested she had seen every variety of human behavior this particular setting could produce, and was not impressed by any of it. Whitmore stood and spent 20 minutes laying out the department's position in the smooth, unhurried cadence of a man billing by the hour. The reclassification had been properly authorized. The economic reality test had been applied correctly. The affected workers had been provided notice and an opportunity to appeal through proper channels. And Ms. Baines, he noted, with a particular kind of deliberate gentleness, was a 23-year-old analyst on administrative leave whose personal relationship with one of the affected workers raised serious questions about the reliability and impartiality of her findings. He did not say her mother's name. He said one of the affected workers, the way you'd say a variable in an equation. When Ivory stood to present her opening, the room was quiet in a particular way. Not respectful quiet, waiting quiet. Whitmore sat back in his chair. One of his associates looked down at her phone. Judge Shen looked at Ivory over her glasses with an expression that was professionally neutral and nothing more. "Your Honor," Ivory said, and her voice only shook for the first syllable. The department's own published guidance on worker classification states that the economic reality test is not a checklist. It is an assessment of the totality of the working relationship. I intend to demonstrate, using the department's own records, its own communications, and its own guidelines, that the reclassification of these 15 workers fails every material criterion of that test. And I intend to demonstrate that the individual who authorized that reclassification knew it. Whitmore smiled. Not at Ivory. At the table in front of him, the smile of a man setting down a heavy bag because he already knows he doesn't need to carry it any further. The first 2 days were a controlled demolition of everything Ivory tried to do. When she attempted to introduce the original employment contracts, Whitmore objected that they predated the redesignation period and were therefore irrelevant to the current classification structure. Judge Shen sustained it. When she tried to call one of the affected workers to testify about her day-to-day working conditions, Whitmore argued that anecdotal testimony about individual experience was inadmissible without first establishing an evidentiary foundation through documentary evidence. Judge Shen sustained it. When Ivory tried to introduce the public records she had requested, Whitmore argued that the documents had not been properly authenticated under the federal rules of evidence. Ms. Baines, Judge Shen said, on the afternoon of the second day, removing her glasses and rubbing the bridge of her nose. I understand what you are attempting to argue. I can see the framework of your theory. But you cannot simply present documents without proper foundation. Authentication is not a technicality. It is a fundamental requirement, and without it, I cannot admit what you're offering. Your Honor, these documents were produced by the department itself in response to my public records request. That does not automatically authenticate them in a formal proceeding. You need a witness with personal knowledge. The department won't produce the records, custodian. I subpoenaed them and counsel filed a motion to quash, which I granted, Judge Shen said, because you did not properly establish necessity. Whitmore said nothing. He was reading something on his legal pad, relaxed as a man on a porch. On the second evening, Ivory sat in her mother's kitchen until 2 in the morning. Ruth Ann had gone to bed at 10. The house was quiet. The folder was open on the table. She was losing, not because she was wrong. She was not wrong. The documents in front of her were unambiguous. The reclassification was illegal. Marsh had known it was illegal. But Whitmore was using the procedural rules of the hearing the way you'd use a broom to sweep evidence under a rug. Every time she got close to something real, there was an objection. Every time there was an objection, there was a rule she hadn't perfectly complied with. Every time there was a rule, Whitmore had a motion ready. She had studied the law for 9 weeks. He had lived in it for 30 years. She pushed the folder away and stared at the ceiling. Then slowly, she pulled it back. She was looking at the wrong thing. She had been trying to fight Whitmore on his terrain, using evidence he could object to, calling witnesses he could exclude. She had been playing the game he wanted her to play. What she needed to do was find the thing he hadn't thought to protect, the thing he was so confident she couldn't use that he hadn't bothered to build a wall around it. She opened her laptop and pulled up the public records response again, all 460 pages of it. She had read it, but she had read it looking for evidence of the reclassification. She had not read it looking for evidence of what happened after. At 11 minutes past midnight, she found it. Buried in the internal email thread on page 312, 3 months after the reclassification took effect, was a message from Marsh to his deputy director. The subject line was, Compliance Review Timeline. The body of the email contained 2 sentences that Ivory read 4 times in a row before she allowed herself to understand what they meant. Legal flagged the web reclassification as potentially non-compliant with FLSA 203A. Suggest we finalize the garnishment collection before any formal review can be initiated. Legal had flagged it. Marsh's own legal team had told him the reclassification might be illegal, and his response was not to pause the reclassification, not to investigate, not to restore the worker's status while a proper review was conducted. His response was to accelerate the collection of money from those women before anyone official could tell him to stop. He hadn't made a calculation. He had made a decision. A deliberate, documented, time-stamped decision to collect money from 15 workers that he had been told he might not legally be allowed to collect. That was not a civil violation. That was not a compliance error. Ivory knew the term for it, willful violation. Under the Fair Labor Standards Act, a willful violation carried double damages and extended the statute of limitations from 2 years to 3. But more than that, under certain conditions, a willful violation could trigger criminal referral under 29 U.S.C. Section 216, the criminal penalty provision of the FLSA. She also understood, suddenly and completely, why Whitmore had worked so hard to keep her documents out. He knew the email was in there. It had to have been in there, when the department compiled the public records response, which meant Whitmore had known from the beginning that if Ivory got the documents properly admitted, that email would be in evidence. And he had spent 2 days building procedural walls to make sure she never got there. But he had miscalculated one thing. He had filed a motion to quash her subpoena for the records custodian, and in that motion, his firm had submitted a supporting declaration from the department's own records officer, confirming that the documents produced in response to Ivory's public records request were authentic records maintained in the ordinary course of government business. It was a standard declaration. Boilerplate. Filed to support the motion to quash, not thinking about what else it established. It established authentication. Whitmore had authenticated the documents himself. Ivory sat back in her chair. She spent the next 3 hours preparing not a new argument, but a trap. She wrote out exactly what she was going to say, exactly how she was going to say it, and exactly where the exit would be locked before Whitmore realized the door was closing. When the sun came up, she changed her clothes, kissed her mother on the forehead, and drove back to the federal building. She had walked in 2 days ago as someone trying to prove she was right. She walked in today knowing she already had. The hearing room felt different on the third morning, though nothing had physically changed. Same chairs, same fluorescent lights, same slightly uneven table that wobbled when Whitmore rested his elbow on it, but something had shifted in the air. Ivory felt it in her own body, in the particular stillness that settles over a person who has stopped being afraid because they have found the flaw beneath the fear. Whitmore noticed. He gave her a brief, assessing look when she entered, then looked away. It was the look of a man who has learned to read rooms and has felt something he doesn't quite have words for. Judge Shen called the hearing to order. Miss Baines, you indicated you had additional evidence to present before we move to closing arguments. The floor is yours. Ivory stood. She did not bring her notes. She had memorized everything. Your Honor, at this time, the complainant moves to admit into evidence respondent's own records production in response to public records request number 2023, WHD 04417, specifically including all email communications contained therein. Whitmore was on his feet before she finished the sentence. Objection. Authentication. Ms. Baines has failed to establish foundation. Your Honor, Ivory said, her voice level and clear, authentication has already been established. I direct the court's attention to the declaration submitted by respondent's counsel in support of their motion to quash complainant's subpoena for the records custodian. In that declaration, the department's own records officer, Mr. David Crowley, stated under penalty of perjury that, and I'm quoting directly, all documents produced in response to PRR 2023, WHD 04417 are authentic records of the Department of Labor, Mid-Atlantic Regional Office, maintained in the ordinary course of government business. That is the legal standard for authentication under Federal Rule of Evidence 901. Respondent's own counsel established it. The room was quiet. Whitmore did not move for 3 full seconds. Then, very carefully, he looked down at the declaration in his folder. Ivory watched him read it. She watched the moment he understood. Your Honor, he said, and for the first time in 3 days, his voice did not have the easy weight of a man who already knows how something ends. The declaration was submitted in a limited context for a specific procedural purpose and cannot be construed as blanket authentication of the entire production. Counsel, Judge Shen said, looking at the declaration herself now, reading it slowly. That is not what this says. This declaration is not limited in scope. It authenticates the production as a whole. She looked up. Objection overruled. The records are admitted. Ivory set the folder down in front of the judge. Your Honor, I'd like to direct the court's attention to page 3 and 12 of the admitted production. She read the email aloud. She read it slowly, without commentary, without emphasis, without drama. She let the words do what they were there to do. Compliance review timeline. Legal flagged the web reclassification as potentially non-compliant with FLSA 203A. Suggest we finalize the garnishment collection before any formal review can be initiated. Signed, Clifton Marsh, Regional Director, October 14th. The stillness in the room was the kind that happens when something irrevocable has just occurred, and everyone in the room knows it, and is deciding what to do with it. Whitmore said quietly, Your Honor, I'd ask for a brief recess. We'll finish the morning session first, Judge Session said. She was looking at the email. Her expression had not changed exactly, but something in it had become very focused, the way a lens focuses when you turn it toward something worth seeing. Ms. Baines, please continue. Ivory continued. She walked through the economic reality test, factor by factor, using the department's own records to establish each element: schedule control, equipment provision, permanency of the relationship, integration into the regular business, all of it documented, all of it in the production Whitmore had authenticated. Then she presented the legal framework. Section 203 MA of the FLSA, the department's own 2014 guidance on contractor classification, authored in part by Clifton Marsh, the specific standard for willful violation, the criminal referral provision. The email on page 312 establishes that the department's own legal team advised Regional Director Marsh that this reclassification was potentially non-compliant before the garnishment collection was completed. His response was not to halt collection. His response was to accelerate it. That is not a compliance error. That is willful conduct. Under 29 U.S.C. 216A, willful violation of the FLSA's wage provisions is a criminal offense subject to criminal prosecution. Whitmore stood. Your Honor, she is not a prosecutor. She cannot threaten criminal referral in an administrative proceeding. She's not threatening, Judge Shen said. She's citing statute. That's within scope. She made a note on her pad. Continue, Ms. Baines. Ivory looked at the folder. Then she looked at the gallery, where Ruth Ann sat in the second row, very still, her hands folded in her lap. These 15 women showed up every morning, Ivory said. They cleaned this building. They cleaned the office where the decision was made to take money from them. They were told the rules had changed. They were told they owed money back. They believed it because they trusted that the institution they worked for was operating in good faith. She paused. It was not, and the person responsible for that knew it was not. I am asking this court to restore every dollar taken from these workers, with liquidated damages as provided under the FLSA for willful violation, and to refer the conduct of Regional Director Clifton Marsh to the Office of Inspector General for criminal investigation. She sat down. The room stayed quiet for a moment, longer than felt comfortable. Then Judge Shen removed her glasses, set them on the table, and looked at Gerald Whitmore with the specific expression of someone who has just finished reading a document they wish they had read more carefully before today. Counsel, she said, I'm going to give you an opportunity to respond. I would suggest you respond carefully. Whitmore's response lasted 4 minutes. It was the shortest argument he had made in 3 days. When he sat down, he did not look at his associate. His associate did not look at him. Judge Shen did not deliberate. She was already deliberating. You could see it in the way she was reading the email again, and then the declaration, and then the statutory language Ivory had cited, moving between them with the focused economy of someone assembling something that has now become clear. She looked up. In 31 years on the bench, Judge Shen said, I have reviewed a significant number of worker misclassification cases. What I have not frequently seen is documentary evidence of a decision-maker receiving legal advice that a classification may be non-compliant and responding to that advice by accelerating collection before a formal review could be conducted. She set the papers down. This court finds that the reclassification of the 15 affected workers under the redesignation of November 2022 did not satisfy the economic reality test, and was therefore unlawful under the Fair Labor Standards Act. The complainant has established, by documentary evidence, authenticated by respondent's own counsel, that the violation was willful. The court orders immediate restoration of all garnished wages, with liquidated damages equal to the amounts unlawfully collected, to be distributed to each of the 15 affected workers within 30 days. She turned her gaze to the corner of the room, not at Whitmore, not at Ivory, but at the door, as if she could see through it to where certain things would need to go next. Furthermore, the court is referring this matter, specifically the email communication entered into evidence, as page 3 and 12 of the admitted production, to the Department of Labor Office of Inspector General for review of potential criminal violations under 29 U.S.C. 216A. This referral will be made in writing before close of business today. She picked up her pen. The department will also show cause within 14 days as to why Regional Director Marsh should not be suspended pending the outcome of that investigation. She looked at Ivory. It was a brief look, professional, but there was something in it that was not professional. something that was simply one person recognizing another across a table. "This hearing is adjourned." The gavel came down. Ruth Ann was the first person in the room to make a sound. It was not a word. It was the sound a person makes when something they have been holding for a very long time is set down, when the weight lifts and the body doesn't know what to do with the absence of it. She pressed both hands over her mouth. Her shoulders shook. Ivory crossed the room in 5 steps and put her arms around her mother. "It's done, Mom," she said. "It's done." Behind them, the sound of Gerald Whitmore closing his briefcase was very quiet. He did not say anything on his way out. Neither did his associate. They moved through the room the way people move when they would prefer not to be looked at. Outside the federal building, the afternoon had turned overcast, the kind of flat grey sky that makes the world look like a document under fluorescent light. Reporters who had picked up the story on the court docket were waiting near the steps. Ivory had not expected them. She stopped at the top of the stairs, Ruth Ann beside her, and looked at the cluster of microphones and notebooks and phone cameras. "Mrs. Baines," one of them called out, "how does it feel to take on the federal government and win?" Ivory thought about that for a moment. "I didn't take on the federal government," she said. "I took on one person who used the federal government as a cover." "There's a difference." She put her hand on her mother's arm. "These women spent years doing work that mattered, in a building that was supposed to represent the law, and someone decided they weren't worth protecting. I just made him prove it in writing." She looked into the nearest camera. He was very helpful. Ruth Ann laughed at that. A real laugh, the first one Ivory had heard from her in months. The OIG investigation moved quickly. Within 6 weeks, Clifton Marsh had been placed on administrative leave. The criminal referral was pursued. 3 months after the hearing, he was indicted on 1 count of willful violation of the Fair Labor Standards Act and 2 counts of obstruction related to the suppression of the legal team's compliance memo, a second document that surfaced during the OIG review, one that Marsh had apparently instructed his assistant to delete and which had been recovered from the department's backup servers. His defense attorney was not Gerald Whitmore, who had quietly declined to continue the representation. The 15 workers received their back wages and liquidated damages within the 30-day window. Ruth Ann Baines received a check for $6,240, the garnished amount plus interest and liquidated damages combined. She framed the check before she deposited it. Ivory was reinstated with full back pay. She declined, politely but clearly, to return to the same regional office. She accepted a position with a non-profit wage enforcement organization in Baltimore, where she made considerably less money and worked considerably harder, and found, for the first time in her professional life, that the work felt exactly like what she had thought it would feel like when she started. Clifton Marsh was convicted 14 months later. The judge, in sentencing, noted that his conduct represented a particular kind of corruption, not the dramatic kind that makes headlines, but the quiet, administrative kind, the kind that happens inside procedures and memos and redesignation forms, the kind that relies on the assumption that certain people will not know how to fight back and will not try. He had been wrong about that. The law, when it is used the way it was designed to be used, does not care how long you've worked in it. It does not care how expensive your watch is or how many times you've argued before the Supreme Court. It is not a ladder that certain people own and others are forbidden to climb. It is a structure, and a structure, if you understand it well enough, can be entered from any door. Ivory Baines had found the door.